Welcome to All Things Real Estate, where my guests and I will answer tricky real estate questions you didn't know you needed to ask. Hello there. Thanks for tuning in. I know that many people invest in real estate and become landlords, but they may not be that well versed in dealing with tenants as a landlord. So today, I've invited Bita Di Lisi from Stonegate Legal Services to talk to us a little bit about that. Really, just the tip of the iceberg, but you can hire them as well. Stonegate Legal Services is a family-owned boutique legal firm focusing on landlord and tenant matters throughout Ontario. Some of the practice areas they serve include non-payment of rent, late rent, evictions, termination of tenancy, and owner reoccupying the property. Hey, Bita, how are you?
Good morning. Good, Sandra. How are you?
I'm very well. Thanks so much for joining us and sharing your wealth of knowledge so that we can benefit from it, and also the ability to hire you. And if I forget later, I just want to tell you that Bita has been so gracious to offer us a link to some downloads, and they're fabulous resources for landlords. So take advantage, click the button. So Bita, let's talk about, I guess, the most common questions that new investors who suddenly become landlords need to know, because really, even today, we're just scratching the surface of everything you need to know. That's why your business is so viable, because you specialize in this stuff. But for example, a lot of people don't know what happens if my tenant stops paying rent.
That is a great question. That is one of the common questions we get asked all the time. And before I get too deep into that, I want to say that as a landlord, anytime you purchase rental property for the purpose of rental income and you become a landlord, you're taking on a risk. One of those risks are non-payment of rent, right? Another one is damages. For non-payment of rent, you have to go through a process, meaning you have to go through a procedure to get the tenant out, which means you have to serve notice, file it with the board, and then wait for a hearing. And then on the day of the hearing, you can inform the board or update the amount of rent arrears owed from the date that you served the notice to the date of the hearing.
Yes. So a landlord has a tenant who isn't paying, and there's forms to be filled out. What does the landlord do? Does the landlord fill these out on their own?
The landlord can fill it out on their own, or they can contact a legal representative to do it for them.
So a lawyer?
A lawyer can. Usually lawyers don't practice in this type of law. Paralegals are the ones that practice in this type of law, just because it's not really worth it for lawyers to do. But there are lawyers who practice in landlord and tenant board tribunals.
But they're not really specialists. Your lawyer, your real estate lawyer, is not a specialist in this.
No.
What I'm trying to say is they have to reach out to you, Bita.
They should be reaching out to us.
Yes,
we are your guys.
Because most landlords won't be able to fill out the forms appropriately. And even, see, I've been on the website and it says, oh, okay, non-payment, fill out this form. But it doesn't tell you then that you have to register it, right?
That's right.
It doesn't tell you every step. So
That's
the
right.
poor landlord thinks that, oh yeah, everything's done, I filled out the form. No, you're just starting.
That's right. And those notices have deadlines. They have requirements. If those deadlines are not met, and I'm talking about applying that notice to the board within the time period that you're required to, then there's another error. You haven't followed procedure properly. Remember, you're dealing with a government body. And in government, for those of you who are familiar, you have to follow procedure properly.
Definitely. Right. So how can you terminate a tenancy?
Well, that's a great question. A lot of realtors or even landlords, they find that, they call us and they say, well, my tenant isn't allowing for showings. Can we end the tenancy, or the lease is coming to an end? Can we kick the tenant out? There's only 3 ways to end the tenancy. Number 1, if the tenant decides to leave and gives notice. Number 2, mutual agreement. Or number 3, by way of a court or board order. That's it.
So when you say mutual agreement, what does that look like? We just verbally agree?
You verbally agree, and then you have to draft an agreement or go, contact the legal representative to, fill out the appropriate agreement. sign it, have all parties sign it, and then, which a lot of people don't know, Sandra, they have to file that agreement with the board. Because at the end of the day, we are all people. People change their minds all the time. What happens if that tenant changes their mind and you don't file with the board? Well, an agreement has no enforcement behind it until you have an order.
And I think that's the step that a lot of people don't know about, because when you go on the website, it's not clear.
That's right.
There's no flow chart, right? First do this.
Oh, that's right. That's right.
So this again is why they should be hiring you. Because honestly, for the headache that you could encounter if your tenant decides not to move out and you're counting on that space for whatever reason, or like I'm telling you, if you fail to cross a T or dot an I, boom, it's thrown out. Just get a pro to do it right. Why bother yourself? You're not going to become a landlord tenant expert on your own. If you own one investment property or even two, like you're not going to, even if you own multiple, 30 of them, you don't want to do this job, right? No. So just hire a pro to do it. Then it's done properly and it'll go through the, the required channels and it'll get the job done. So what is an illegal deposit? What are illegal deposits?
Okay, so let's talk about that. Legal and illegal deposits. Legal deposits, a landlord can collect a deposit on or before the start of a new tenancy. That deposit cannot be more than 1 month's rent, and it cannot be applied to anything else except for the last month of the tenancy. So I know that common practice when you're looking at a rental property with the realtor, you put a first and a last deposit to secure the property. Really, the first month's rent is not due until the first day of the tenancy. But legally, a last month's rent must be provided to the landlord. It can be kept for the to be placed towards the last month's rent. There is an exception for other deposits, being a key deposit, a refundable key deposit. The Ontario Standard Lease has a section where parties can agree that the tenant will provide a refundable key deposit. Now, that key deposit can only be for the cost to replace that front door key. Not the garage door remote, not the fobs, not the locker room key, not the party room key. You see where I'm going with this? Only the key for the front door, not the locking mechanism, not the hinges, just the front door key. Any other deposit is an illegal deposit, cannot be obtained by the landlord or held by the landlord. In fact, if the parties voluntarily agree to a higher deposit or a further deposit, which is an illegal deposit, that tenant can bring an application to the board and request a refund, which I find is happening nowadays because rentals are just going multiple.
So when you're moving into a condo, you need a fob, and it's like $100 or $150 for that fob. So the landlord can't get the deposit for that?
Not a fob, a key.
So the garage door fob, nothing like that. However,
remember we spoke about the risks, Sandra? Yeah. This is another risk. Right? It's the cost of doing business.
Exactly. And this is a business. This is what I want the public to understand. You're going into business for yourself, but this is the cost of doing business, right?
It is 100%.
That's very interesting. I wasn't aware of that. So that's brilliant. Thank you so much. So now I know a lot of landlords want post-dated checks. Now, can they demand a certain form of payment?
That's a great question as well. In accordance to the Act, and I know that in the Ontario Standard Lease, there's a section that parties can agree to a method of rent payment. And usually it's post-dated checks. In accordance to the Act, a landlord cannot demand a method of rent payment. If the tenant changes their mind and says, hey, I don't want to pay by post-dated checks, I want to send you an e-transfer, then the landlord has to accommodate for the tenant to pay their rent by any way that they're comfortable making the payment.
Okay. So, I mean, not too many people use checks anymore. So we've been seeing more and more e-transfers, which doesn't give the landlord any confidence that they have the next month's rent already in their possession, ready to be deposited on the first.
But neither does a check.
Yeah, because they could bounce, right?
It bounce. But I'm a huge fan of e-transfers. I'll tell you why, Sandra, because number one, I like to automate. So,
Mhm.
and then make it easy. Number one, the tenant will send the rent, it automatically goes into the account. There
Mhm.
are no holds, and the tenant gets notified and is provided a receipt. So
That's
I
right.
don't have to make time out of my day to provide them with a rent receipt.
Yeah. No, I
It's
like
already
it too. But I know that a lot of landlords are thinking, well, I don't have the security of that rent in my hand, right? Or photocopied and I already deposited at the bank because the bank used to give you a service that you would pay for and they deposit it for you. So, okay, so it's interesting to know that you cannot demand a certain format
right.
of payment or form of payment. Here's a question that came up recently. It was a clause that I saw and it said, we all know that you have to pay the rent by the certain date. Let's call it the first. Okay. It could be any day of the month that you agree on, but let's say it's the first. But let's say a week before the first, they're shooting you 30% of the rent. And then 3 days before the first, they're shooting you another 30% of the rent. And then on the first, they're giving the last portion owed. And some people don't want that because it's terrible for accounting. Can a landlord say, can you just please pay in one payment?
No, no. The tenant is paying. You're lucky that
Right.
the tenant is paying, right? And here, that's another risk.
Yes, of course. Yeah. Okay. So that's interesting because this is an issue. A lot of times we see landlords demanding things that are not within their legal rights. And
Right.
so if in an agreement it says something like, I want to get to the no smoking and no pets kind of thing because that's a real big issue. But if in the agreement it says the tenant agrees to do this and this, and the tenant knows that it goes against the code, and the tenant signs the agreement anyway, what happens then? Can the tenant then say, well, I don't need to follow that, or what happens?
Yeah, they can.
Yeah.
So let's talk about the lease for a minute. Okay. So the lease agreement, I call it the rules of the game. It outlines the rules. Who are the tenants? Who are the landlords? Where's the rental property? How much is the rent? What does the rent do? So forth and so on. Parties cannot agree to give up their rights under the act, even if they sign. That includes a pet, not having a pet, right? There's nothing that a landlord can do. If there's a term in the rental agreement that's inconsistent or contrary to the act, that term is automatically void and unenforceable.
But
Even
not
if
the rest of the contract.
that's great to clarify as well. It doesn't nullify your contract, nullifies that term. That
Right.
term is unenforceable.
So let's talk about pets, because a lot of landlords will say, I don't want any pets. But unless the condominium rules are no pets, what can the landlord do?
That's the exception. Condo rules or condo corporation has their own rules regarding pets, and that needs to be clarified, and make sure you provide your prospective tenant with a copy of the rules, and make sure they initial next to the no pet clause, right?
Right.
The law says that a tenant is allowed to have a pet. So even if the parties agree and you enter into a tenancy and then the landlord comes to do a repair 3 months after, they find out that there's little Fluffy in the property, they can't do anything, even
Right.
if the parties agreed. And that's what I find is happening now, Sandra. People are like prospective tenants are lying on their
I
applications
know.
because landlords are restricting them.
Mm-hmm.
I can answer if it is a dangerous pet. Then the landlord can apply to the landlord and tenant board, have the matter heard, and then have the board decide the fate of that application. But I have to say, just because a breed says that a pet is dangerous doesn't mean that particular pet is dangerous,
Right.
because the board is not going to say, well, Sandra, you have a pit bull, get rid of it. No, the board's going to say, Sandra, I see your little Fluffy. Has Fluffy attacked anyone?
Mm-hmm.
Is Fluffy friendly? Is Fluffy around children? It
Mm-hmm.
really depends on the owner than on the pet. So
Okay.
the board, there are other factors at play, even with a pet that's a dangerous animal.
Right. Like, would boa constrictors be considered dangerous?
They can, but they're considered dangerous if they are set free, right? I mean, they can go through pipes and up
Yeah.
toilets. We've had
I mean,
happen.
I don't want my next door neighbor in a condo to have a
right?
boa and it escapes and comes through the vent into my place, right?
That's right. That's right.
Okay, so the rule is they can have the pet if the pet has either been known to be dangerous or then becomes dangerous, then it must be removed.
Yeah. 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 Unless that dog or the boa has physically attacked someone, then
Yeah.
the board will take it a little seriously.
Well, with the dog, usually there's a muzzle
Right.
order on the dog, right? So
That's
then
correct.
going through the common areas, you'd have to have a muzzle. Now, I think there's another exclusion if they're living in the same house, like let's say it's a triplex and it's shared HVAC and there's a serious allergy, then the landlord can say, my tenant on, unit 2 has a serious allergy, or if you're moving into my house with me, like you're in an auxiliary apartment, I or my child has serious allergies, so you can't have certain pets.
So you have to prove that serious allergy,
Right.
right?
Okay.
There has to be some sort of a medical report, an updated medical report proving the allergy, perhaps medication. I mean, anyone can say they have an allergy, right?
Mhm. Okay. What about smoking?
Smoking, let's talk about that. Smoking, the act doesn't make direct reference to smoking. What the act says is that if a tenant interferes with the reasonable enjoyment of other tenants or the landlord, then the landlord can apply under the act to terminate tenancy. So if, for example, you have someone that's a fiend and smokes like crazy, and the I guess the smoke is going through vents and interfering with another tenant's enjoyment, well, then they can bring an application. But I'll tell you from my experience, proving an odor or a sense of you have to prove how that is interfering with their enjoyment,
Mm-hmm.
right? Secondhand smoke, yeah, I mean, it's a health concern, but proving smoking is really difficult to get an eviction on at the board.
Unless it's a non-smoking building.
Unless it's a non-smoking building, which you should know beforehand, so
Yeah.
you let the prospective tenant know.
Exactly. Okay. Somebody told me this, and you get a lot of misinformation out there. So I just want to run it by you because a lot of landlords listening to this might have heard this as well. If you want to designate your property as non-smoking, you really just have to get a sign made that said this is a non-smoking property.
Yes, and it has to be in your lease agreement. It
Okay.
should definitely be this property is a no smoking property. But again, tenants can smoke outside and away from the property per the city bylaw.
Yeah. Yeah. Yeah.
So they can do that.
And marijuana, now that it's legal, that's been a big issue as well.
Yes, but let's talk about marijuana because marijuana is a little different than smoking.
Okay.
Medicinal marijuana, people have licenses for that can prevent a tenant from being evicted if they require that
Right.
medicine,
Even in a smoke-free building?
even in a smoke-free
Okay.
building.
Okay.
Yeah.
Okay. Good to know. Okay, so a lot of landlords now want to sell their property and they just want to evict the tenant because it's going to be easier for showing. They can fix it up, do some staging, and easier to show, easier to sell. Let's talk about that because that is a cesspool.
Yes, it sure is. Well, I'm a huge fan of cash for keys, a huge promoter of cash for keys, especially when it comes to these type of situations, because there is no other way to get a tenant out because a landlord wants to sell. During COVID, especially, Sandra, the number one challenge that a lot of landlords were facing was access to the property. Just because everybody was working from home, schools were being, online, and people didn't want prospective buyers walking into the property, especially during COVID while they were working or they were doing online schooling. So a lot of realtors were saying, well, they're not allowing for showings. Well, the only way to get them out really is to pay them out, cash for keys. And cash for keys is basically offering a buyout in order for in return for a termination of tenancy.
Right.
Realtors, landlords, do not do this yourselves. You don't really know what you're doing. and then you call me and you say, well, I negotiated and the tenant didn't leave and I paid them. And then it's too late because then you're in a bigger mess.
Yeah.
So cash for keys is definitely the way to go prior to you listing the property.
Yes.
That way, once the tenant is out, you can do whatever you want. You can
Exactly.
stage it, paint it, change the roof, give it curb appeal. You're not going to have access with requested showings, restrictions. You're not going to have issues with vacant possession. You're not going to deal with any of that stuff.
Mhm.
Get them out.
So cash for keys is one of the ways that you can terminate an agreement. And let's say they signed a 1-year lease, the tenant and the landlord, and in month number 9, the landlord suddenly has to sell the property. Can you still agree, even
Yes,
though it's during the time of the tenancy, the term? Yeah.
absolutely. We call the shots. That's another reason why I love cash for keys. Cash for keys can be done within the lease, after the lease, without a lease. Like, it doesn't matter. We call the shots. And the best part is you have an influence on the outcome,
Yes.
right?
Yeah. It can be expensive, but when you're selling property in Toronto, for example, it could be worth it.
Be worth it. Absolutely.
Because a lot of times the rent doesn't cover the monthly expenses for a new investor to take on your tenant, right?
Right.
And
right.
please don't try to lie. You've got a tenant that hasn't paid in 6 months, and now you're just going to sell, and you're going to lie to the prospective buyer, landlord, that, oh yeah, they're good. You're going to have to prove that they've paid. So
Yes.
you can't lie your way out of that one. So
Not
that's
lie.
an unfortunate situation that I hope nobody ever gets into. I want to talk about typical duration of leases. Now, most people want 1 year, but I see a lot of people landlords asking for multiple years. And personally, I don't think that's a good idea. So what do you think of like 2, 3, 4 year leases?
I don't think that's a good idea at all. At all. No, because you're tying. See, I'm not sure why landlords think this way. They think that if they can lock down a tenant for 2 years, then they're guaranteed rent for 2 years. And no, you are basically tying yourself down, because what you're saying is, I can't sell the property for 2 years. I can't move into the property for 2 years. That's what you're saying.
You restrict your options.
That's right. No one benefits from a lease except for the tenant.
Exactly.
Because they are the one that guaranteed housing for 2 years.
That's right. That's right. So, and also after the initial term, whether it's 1 year or 6 months or 2 years, whatever you've decided, it legally goes to month.
Correct.
Can a landlord insist that the tenant sign another lease for a 1-year term, for example?
They can ask, but the tenant is not obligated. I don't know why they would even want to sign another lease. It doesn't make sense. But if that's what they want to do, they can, but the tenant is not obligated to sign a new lease.
Tricky situation. 2 people are on the lease, and after, I don't know, 2 years, so the lease term was 1 year, say, now it's month to month, one of the people moves out. Do you have to change the lease to have just the one person on it?
No, that person, well, first of all, if you're still within the lease, both parties are legally and severally liable for that lease. At the end of the day, it's still a contract.
Right.
Right.
What about
But
after the term?
After the term, that person who's on the lease can just carry it forward. That's fine.
Okay,
The
so it
remaining
doesn't
person-
matter that you have this person that's been living there for 5 years, it's gone month to month 4 years ago, and the other person's no longer living there. That doesn't matter.
Correct.
And so that
doesn't
other person is no longer obligated.
No. Once the lease is on month to month, then it's expired. That if that person moves out, there is no contractual obligation between them and the landlord.
Okay. Now, when you take that last month deposit, a lot of landlords don't know that you're supposed to be paying interest on that, right?
Yes. That's a great one too. Yes. Most landlords don't know, and and it's fine, but you can pay interest on the last month's rent deposit when the tenant moves out as well.
And topping up the last month rent. So for example, in 2018, they gave you $2,000 for last month rent. By the time they move out, rent is now $2,300. So how do you deal with that? The increase in rent on the last deposit plus the interest. It's a lot of accounting for a typical person who owns one rental building or multiple and is a busy person in life. So what's the best way to deal with this? That is within the law.
Well, remember, you have to treat this like a business. So you have to make time for your business. But anytime you serve notice for rent to be increased, you can ask them to top up the last month's rent deposit. Ask for a top up. If you don't ask, you don't get.
Okay, so you ask for the top up and then you pay the interest. It's usually around the same amount, right? So at the end of the day, if you didn't pay the interest, it's a wash, right? Pretty much.
Yeah.
Okay. Can the landlord get in trouble for not having paid the interest? Let's say the guy's been there for three years and he says, hey, I just found out you're supposed to be paying me interest on my deposit. Can the landlord get in trouble?
Not in trouble. I mean, they can get ordered to pay the interest.
Okay.
I mean, the board's application filing fee is much more than the interest anyways.
Just pay it, keep a record.
That's right.
There. Is there anything else that you want the public to know about being a landlord?
The most important thing for the public to know, I've been reinforcing it throughout our talk here, is you have to treat this like a business.
Yeah.
You can't put the responsibility for repairs on the tenant. You can't put the responsibility to change furnace filters on the tenant. Furnace filters are responsibility of the landlord. You can't say, hey, tenants, shovel the snow and maintain the property, and just send me the rent. You can't, you have to treat it like a business, and you have to be hands-on. And I'm really hard on my landlords. And I say, if you're not prepared to do this, get out of the business.
Yeah.
Get out of the business.
But isn't there a way to compensate your tenant for clearing the snow?
There is.
Legal?
There is, but you have to have a separate contractor's agreement. The tenant still has to agree, right? And you have to pay them compensation to do it. Not redo rent.
It can't be in the lease. It has to be a separate contract.
Correct. Remember, clauses that are contrary to the act in the lease are unenforceable and void. That includes snow removal.
Okay. Can a landlord who owns a single detached home that is subject to utility bills like water, sewer, garbage collection, charge the tenant for that? Can that be the tenant's responsibility?
I mean, they can agree to that, but I mean, utilities you can agree to. So water charges you can agree to, hydro you can agree to, heat you can agree to. Equipment, mechanical equipment. Let's talk about that. The hot water tank, I mean, there's a rental fee. If it's a rental, you cannot request that the tenant pay that rental fee. The tenant is not obligated to pay, a fee to maintain the landlord's rental equipment.
Okay, so that would include a heat pump if there's an extra charge on a condo or whatever. It's just that should just be included in your rent, your numbers, see what you can get for rent and cover that. So that also includes maintenance fees. You are not allowed to require the tenant to pay your maintenance fees. And even if the maintenance fees and property taxes and some equipment rental and everything went up beyond the allowable increase in rent, because it's prescribed by the government, right? Every year it's different. You have to check. So even if your cost now went above, let's say they increased 3% and you're only allowed to increase 1.8%, you cannot ask for the extra money.
Cannot. The tenant is only responsible for rent and or utilities. That's it. That's it. Your costs, remember, you're running a business. Your costs have nothing to do with the tenancy. Right. That's your costs. Those are write-offs.
Yeah.
Right?
Yeah. So now that your interest rate ran up, you can't just all of a sudden say, I want more rent. Especially if you're on a 1-year lease in the middle of the lease. You can say, Right.
Yeah.
Okay. So it is a cost of doing business. And what I want to say as a realtor and an investor, I want to say that when you get into this business, think of long-term benefits because your tenant is paying down your principal of your mortgage. So your mortgage was $500,000. Your tenants are paying that down year after year. You're building equity that way, number one. Number two, you're building equity in the ownership of the property. So let's say you put 20% down on a property, okay? So
Yeah.
now when your property goes up 5%, let's say, it's not the money you put in that went up 5%. It's the whole property value that went up 5%, which is the thing that some potential investors don't quite understand. Well, I only made 5% and I could have made this on the stock market. First of all, the stock market. But anyways, I only made 5%, but you made 5% not on your money. You made 5% on your money and other people's money. OPM. Remember that? OPM.
Right.
So it's
Other
a beautiful
people's
thing. So if
money.
your property is $1 million, you made 5% on the $1 million, not the 200,000 that you put in. Just want to clarify that point for those of you who are sitting on the fence, maybe because this conversation was a little bit scary, but very real. You need to know the real side of becoming a landlord. As Bita has said many times, this is a business. Know what you're doing before you get into it. Talk to someone like myself or a realtor who has invested in the real estate market, who has tenants, who has, for example, worked with a lot of landlords and tenants before, but then also have a chat with someone like Bita at Stonegate Legal Services and find out really what's it all about, because landlords do have rights. For example, you have the right to go in and inspect your property. Now, you can't do this every day because that's harassment, but you can go in and there's no limit, right? Bita, some people think it's like only once a year or once every so often. You can go, for example, after they've been in your place for a month or so, you can go do an inspection, correct?
You can, but as long as you don't go every month.
No, exactly. There's no reason.
Right? Yeah, there's no reason.
Yeah, that's harassment. So
can I just jump in there?
Yeah.
But a lot of landlords think, oh my God, I have to go in there to change the furnace filter. No, this is your way in. You're going to change the furnace filter every 3 months. They're giving you access to walk into the property, and down to the basement and change the furnace filter. You're gonna go in there every 6 months to change the smoke alarm battery. Like these are giving you, this is giving you access to the property. Take advantage of it.
Just make sure that you serve notice properly.
That's right.
Yeah. And that's simply notifying them with at least 24 hours notice for the purpose, time of why you're going into the unit. And the tenant has to provide access. So if they have, a deadbolt that they put on, first of all, that's illegal, right? A tenant can't change the locks or add an extra deadbolt.
Can't change the locks. If they change the locks, they have to provide the landlord with a copy of the key.
Right.
So and vice versa.
They cannot prevent you from going into your unit as long as you have served notice properly. And that, by the way, also includes when you have your property for sale with the tenant there, whether or not they're staying, you can still schedule showings, especially, let's talk about Section 3 in the standard lease. Now, if they have said, and correct me if I'm wrong, if the tenant has agreed to receive notice by email, you can serve notice by email that tomorrow, 24 hours from now, there's going to be a real estate showing. Is that correct?
Well, let's talk about that, because even if they agree to that on the lease, the appropriate document that needs to be filled out and signed by the parties is the consent to service via email form. It has to be on the landlord and tenant board form. You can get that on the landlord mastery guide, and that's going to be a link that Sandra will have. So that will give you, that you can definitely attach to your lease as an appendix. That way, parties will agree to receiving notices via email. But Sandra, if the tenant says, Sandra, I don't want to receive email notices anymore, then you have to go there and physically post it on the door.
So what is the fee to register the document, the consent to email?
There is no fee to register. The parties would sign it. It's great because the parties will sign it and you can attach it to your Ontario standard lease. That's it.
Okay, awesome. Well, thank you so much. I really appreciate this. Wow, I thought it was going to be just scratching the surface, but I think we got a little deep in here. So, for all of you would-be or current landlords out there, if you have any questions, Bita is obviously a knowledgeable source for you to reach out to. Feel free to reach out to me as well, and I can certainly guide you to talk to Bita anyway. And don't be scared of this. No business is easy.
Yeah,
No business is guaranteed. So definitely do your due diligence, ask the hard questions, make sure you have a great understanding of what's going to go on. It's not, hey, if it was that easy, everybody would be doing it. But I
that's
just
right.
want to make sure that you don't fall into the, typical pitfalls and traps that unknowing landlords do. So thank you so much again, Bita. I really appreciate your time today.
Thank you so much, Sandra, for having me.